Hey everyone, asset protection attorney Brian T. Bradley here. I'm licensed in Washington, Oregon, California, and Michigan. Represent clients all over the nation for their asset protection needs. And though I don't represent you, this is about education and helping you get through the maze of asset protection. So today's quick tip on asset protection is about jurisdiction. And so jurisdiction is probably one of the most powerful concepts in asset protection. And the reality is that the laws that govern are governed differently from state to state and country to country. And this is called jurisdiction. Not all states are created equal, not all countries are created equal. Each jurisdiction will have a say in how secure your assets are going to be in each state. And each state will have different rules that apply for judgments and judgment orders and liability protection for membership ownerships of LLCs. And so you really want to know what those differences are. But it doesn't just stop there. To get the most out of jurisdiction, you want either a legal right called an exemption, which would be federal and state, and you would really want to max out first your federal and state exemptions before going into creating other entities in other states. Or you want a foreign jurisdiction that does not recognize other countries' court orders. And this is because if you're not relying on a legal right like an exemption, then any purely domestic US-based asset protection system can't run from the US Constitution's full faith and credit clause. What this means is that states must honor other state court orders. And this is the hallmark of the US legal system. And so if you want to live in a state that doesn't have or provide a legal right by exemption, like California has a really strong exemption laws for private retirement plans, which we specialize in, then the most powerful asset protection tool that you have would be possibly setting up a foreign trust in the Cook Islands and a foreign asset protection trust, which we also specialize in. And so the Cook Islands passed legislation that permits an irrevocable self-settled spendthrift trust called a foreign asset protection trust. But the Cook Islands didn't just stop there. They also created a statutory framework to protect your trust assets, to the extent that they are actually statutorily prohibited from recognizing any other country's judgments or court orders. And this includes the US. So there's a 1-year statute of limitations to file a case in the Cook Islands. Cases have to be proved by the murder standard beyond a reasonable doubt. US lawyers are not permitted to practice in the Cook Islands. Plus, they'll have to fly in a judge from New Zealand to hear the case and pay all court costs up front. Oh yeah, and if you lose, or if they lose, which they most likely will because they have to prove their case by the murder standard, the highest standard in the world, then they're going to pay your legal costs. So the bottom line is that if you don't have the benefit of federal or good state legal right exemptions to protect your assets with, then the best home court advantage would be utilizing an offshore jurisdiction like the Cook Islands and a bridge trust, which would be the benefit of a foreign asset protection trust with the simplicity of a domestic home base. And so for more information on the amazing exemptions of state exemptions like the California Private Retirement Plan, watch video 4 of mine. And for more information on the Bridge Trust and the Cook Islands, watch video 3. And thanks for watching. And I hope that you guys are learning a lot more about asset protection, the benefits that it has for you, and getting you through the maze of what you should be looking for when you're talking to lawyers and CPAs and what you should and shouldn't do. Take care and have a great day.